Yes, very briefly, Mr. Judge. The application for it was filed last month. It was raised to the attention of this court on the 30th of June, when we came here to this court. This is also a human rights enforcement application. That we expected would be dealt with as a priority. If it had been dealt with, we would not have been in the dilemma we were on the 3rd. We would have resolved the issue of representation. It was not attended to in the hearing of 30th. It was not attended to in the hearing of the 3rd, in spite of raising it in both appearances. The circumstances that propelled that application were not of our own making. They were the making of the state. Which kidnapped Councillor Yassir and tortured him. And which arrested and deported Councillor Martha Kabu. These were the actions of the state. Illegal actions of the state. If they hadn't been there, there would be no application 248. We would have proceeded normally. The details and the evidence in that application can only be dealt with by hearing the application. And if it's business, dismissing it. Regarding the lawyers not notifying prosecution, regarding the lack of instructions, that would be a matter for the lawyers to deal with. It cannot be visited on us. But suffice to say that both on the 1st of July and on the 3rd of July, this open court, we did on the 30th of June, and on the 3rd of July. In this open court, we did put on record the situation of our representation. In their presence.
So, Doctor, this challenge, how long, according to how long can we wait on this debate?
If 248 can be had tomorrow and resolved, then the following day we will have a way forward. It hasn't been had since we filed it last month and talked about it in these subsequent appearances. Again, not for emphasis, since it seems Chief State Attorney Bill Muka didn't get it. The disclosures were made to our lawyers. For us to receive them, we need the facilities through the prisons authorities for the lawyers to now make us access them. So, whereas trial, and indeed they said they had a witness here on the 11th, they had a witness in court. But on the 3rd of July, they themselves read a letter that was now, for the first time, allowing access to facilities, which was written by the prisons authorities on the 29th of June. So we are supposed to hear evidence on the 11th, long before prisons considered to allow facilities to access the disclosures. By the 2nd of July, when that letter came to our notice, and I'm sure to their notice, the crisis of the lawyers had already emerged. So we have no way of accessing them since July the 2nd, when that letter was written. And until the resolution of the legal representation which we are seeking. Regarding what he describes as abuse of process, then I think there must be completely different understanding of the judicial system, the legal and the judicial system we are following. Mr. Birivumuka must be following the indigenous communities judicial system, while we are following the colonial or neo-colonial judicial system, whereas Mr. Museveni said includes the judges who are actors with wigs. Mr. Judge, the absence of our lawyers was occasioned by the state itself, not by ourselves. And it is the state that has progressively abused the process. It was the state which took us to defunct military court-martial, military tribunal, which had long been declared unconstitutional. The state, the guarantor of the constitution, nonetheless took us there and charged us in an unconstitutional court, where we spent months. This court ordered for disclosures last year in December to be concluded by January. In a matter where all investigations were complete in May of last year, yet from December, disclosures were completed in June. Our lawyers begged for sanctions against the state. Every appearance, we wanted the court to sanction the state for not following court orders. Which is the same state saying we are the ones abusing the process. Therefore, constitutional rights must be stripped. So, Mr. Judge, I beg this court to hear our application to resolve the issue of our lawyers. And once resolved, allow us access, allow us time, petitioners. And also to give us the record of proceedings. And we shall be ready to face their witnesses. As I ask for, Mr. Judge.